Good afternoon and welcome. My name is Ed Momkus, and my colleagues Jim McCluskey and Bob Bruce and I are going to be talking to you today about non-compete and non-solicitation agreements. This is the first of a series of webinars that we're putting on for business executives and business owners. And the purpose of today's webinar is to help business owners and executives make better decisions about how to use and how to enforce non-compete and non-solicitation agreements. To make sure that we're really all on the same page, we're going to talk a little bit first about terminology so that we all understand what these words mean when we use them later. And on this slide, you'll see 8 bullet points of terms that are used regularly in connection with non-competes and non-solicitations. And let's look at these one at a time. The first term that we're going to be talking about is consideration. And consideration is that old proverbial quid pro quo, getting something for another thing. In essence, what we're looking for is a description of what we're getting for what we're giving. Because if actually you don't want to give me anything, I don't need to give you anything. And in fact, consideration is a fundamental concept in contract law. If you don't have consideration, it's highly likely that the contract you have, including non-compete and non-solicitation, is actually unenforceable. So this is a very important concept in what we're talking about today. When we use the term restrictive covenants, what we're talking about is a promise that we give in exchange for some consideration that we agree to refrain from doing something we have the right to do. I have the right to really accept employment with any employer. If I'm going to give up that right or restrict it in any way, and you're willing to compensate me for it, that's what we refer to as a restrictive covenant. So these restrictive covenants tend to come in a couple flavors: confidentiality agreements, non-compete and non-solicitation agreements. The term non-compete is, on a very basic level, kind of straightforward. You know, what you're trying to do is either preventing an ex-employee or an ex-partner from competing with your business, in other words, being in the same business. Our focus today is going to be primarily on enforcement of non-competes as they relate to employees. Non-solicitation agreements. Non-solicitation is a bit different than non-compete. In a non-solicitation restriction, what you'll have is someone who can compete with you, but that person can't solicit your pre-existing clients or clients that in some cases you were actually in the process of developing. It's a little bit narrower than the actual non-compete, which prevents you from competing whether or not you're soliciting someone's business clients. Confidentiality. Confidentiality always relates to some sort of a trade secret. You really have to have a trade secret in order for there to be an enforceable confidentiality restriction. Sometimes people make the mistake of thinking that just because they call something confidential, that it actually will be treated by such in the law. You actually have to go through the steps of treating and protecting that confidential information as it is being proprietary to you. And then the final term that we want to talk about just briefly is golden handcuffs. Now, many of you have probably heard the term golden handcuffs in the concept of some kind of system of financial incentives that are designed to keep an employee from leaving employment. That is very true, but it's also possible to structure golden handcuffs so that they have an effect post-employment. An example might be to have a bonus plan which is only vesting at the end of the year on December 31st and only payable 6 months later. Someone who leaves and breaches a non-compete agreement would run the risk of forfeiture of that. So that is how golden handcuffs might actually come in as a non-compete, non-solicitation concept. Okay, so now how do these concepts work altogether. There are three fundamental things that affect non-competes and non-solicitation, and those three items are: number one, sufficient consideration; number two, protectable interests; and number three, reasonable scope. The first question in evaluating any non-compete agreement is whether or not there is sufficient consideration. Remember, consideration was the quid pro quo that makes a contract enforceable. And there are a number of ways in which this is done. With employees, signing a non-compete agreement on the day you start employment is generally regarded by most states as sufficient consideration. There may be an issue if you actually don't have an employee sign it on day one, and in fact you wait a month after someone's been working for you for a while to have them sign it. Obviously, giving people a cash bonus, that can be a separate form of consideration that is sufficient to enforce a non-compete. And there may be things such as deferred comp plans, the granting of equity interests, or a significant promotion. All of those typically would be sufficient consideration to enforce a non-compete and non-solicitation agreement. The next important concept is the existence of a protectable interest. Actually, unfortunately, many business owners think that merely because they want to prevent somebody from competing with them, that is a sufficient reason to enforce a non-compete. But that's not how courts look at it. Courts look at some basic, important protectable interests that are beyond merely the desire to prevent competition. And there are three listed on this slide here: unique relationships, confidential information, and goodwill. Confidential information is the confidential information that you've delivered to the employee. So, for example, if this is information the employee didn't previously have, and you deliver that information to them, you have an interest in protecting that confidential information from being disseminated. Unique relationships and goodwill typically relate to the fact that personal contacts become very important in business. This is most typically in the context of a salesperson or marketing person who develops a very personal relationship with a buyer or other executive at the customer's end and has been paid to develop that relationship over time. And that is a protectable interest. Finally, the important concept to understand is that non-competes and non-solicitations have to have a reasonable scope. By that, we're talking about three particular things. We're talking about the length of the term of the non-compete, we're talking about the territory that a non-compete covers, and we're talking about what we call the functional substantive scope. As a general rule, if you're going to have any non-compete for an ex-employee that runs more than 2 years, you're going to have a really suspect situation, because most courts are going to be skeptical that you really need more protection than 2 years worth to be able to prevent an employee from competing with you. Geographic scope is going to be driven mostly where you tend to do business. If you're doing business in 5 states and in the process of expanding to another 3 or 4, you're going to be able to get those states covered. But you have to be careful about trying to enforce a non-compete that at the time you enforce it is happening in a place that is actually nowhere near where you do business. And finally, when we refer to the functional substantive scope, we're talking about things that lawyers sometimes refer to as janitor clauses. If your top sales guy is tired of all the pressure and wants to make a change and gets a job as a janitor at your biggest competitor, if he's really working as a janitor, you're not going to be able to enforce a non-compete against him in that context. We've listed here in this slide several types of agreements that typically will include some sort of restrictive covenant. And I think that they're self-explanatory. Some of you outside the scope of a non-compete, non-solicitation may have confidentiality and non-disclosure agreements. And those things actually have all sorts of restrictive covenants on what people can do with the information you provide them. They're also found in business sale agreements, partnership agreements, employment agreements, and in severance agreements. So you'll run across these non-solicitation, non-compete agreements in several contexts. One thing I'll just touch on briefly is that there are big differences between how different states enforce, or in some cases don't enforce, non-competes. California is one very important example where non-competes really are not enforceable at all versus employees. They have more limited enforceability in circumstances that involve business sales or partnerships. Finally, I'm going to wrap with just a brief comment about drafting agreements. What you need to know is that all of these factors that we've just talked about become relevant if you're drafting an agreement. And what this means is that if you take something off the shelf and you don't modify it, if you don't describe your protectable interests, if you don't go ahead and really tailor a term for the non-compete or a geography that is something that relates to your business, you're going to have great difficulty later enforcing that non-compete if you have to do so. So with that note, I'm going to turn this over to Bob Bruce, who's going to talk about the next couple slides. Thanks.
Ed did a great job of laying out the roadmap for the various concepts and agreements that are important to this topic. And it puts us in a position to now cover the point in time when an employee is actually leaving as a follow-up to the agreements that are in place. It will be necessary to look at the particular circumstances that are involved in order to assess the risks and possibilities and options that would be available. Reviewing the scenario of the separation is important for understanding the implications and the possibilities. And Jim McCluskey will actually talk a little bit more about the detail of how particular courts and judges will view these kinds of situations. There are basically two possibilities. The employer, him or herself, caused the separation, or the employer involuntarily terminated the employee. The particular court or judge involved in litigating this kind of matter will be very, very crucial, and it will be dependent on that court or judge to determine the possibilities and the likelihood of being able to enforce an agreement. So let's look at the situation first where the employee causes the separation and voluntarily resigns. If the circumstances of the resignation is that it's voluntary without any good reason at all, where the employee chooses to resign for their own benefit, a court would be more inclined to favor the employer in that kind of scenario as a practical matter. It enhances the ability to enforce the terms of the agreement, whichever kind of agreement we're talking about, like the ones that Ed outlined in his presentation. The court will not be predisposed to favor the ex-employee like they might be in other circumstances, oftentimes favoring the employee versus the big corporation, or at least the corporation or company. On the other hand, if the employee resigned for some sort of good reason, it may limit the employer's options as a practical matter. The court or judge, and again, Jim will cover in more detail how particular judges and courts will look at these, but the particular court and judge involved may not be as inclined to favor the ex-employee if it was the employee resigning for a reason for their own benefit. On the other hand, if it's a reason where they have a situation where they have to, or there's a good reason, it may create a different kind of scenario. Another concept that's important to address is whether or not in the particular employment agreement or employment contract that you have, there are future benefits that are provided for. In that scenario where the employee has resigned, it may be possible as a practical matter to claw back those benefits, or to simply not pay those benefits if there is a violation of the agreement occurring over time, especially at the point of separation and on into the future. So that's a concept to keep in mind as we deal with these kinds of agreements and concepts as well. The second scenario is where the employer actually causes the termination. The employer causes determination, say for instance, without cause, without a good or sufficient reason as viewed by a court. It will heighten the scrutiny of the restrictive covenant and may in fact make a court reluctant to prevent an employee from the possibility of earning a living in the future. Again, remember, as a general rule, the courts are going to be reluctant to inhibit an employee from being able to provide a living for him or herself and their family. So it's important to remember that anything that, as a practical matter, favors the ex-employee will just enhance the court's view and a particular judge's view in that regard. If, on the other hand, the separation is caused by the employer for good cause, that will enhance the ability to enforce the restrictive covenant. There is a concept that can also be focused on in this regard, and that is constructive termination. A constructive termination is a situation where, in fact, the employee would submit a letter of resignation, but they're essentially forced to. They've been discriminated against or retaliated against in some sort of scenario, in some sort of fashion, and the court may view the termination, although in some ways a resignation, in actuality it could be viewed as a termination or involuntary resignation, which would inhibit the employer's ability to enforce the terms of the restrictive covenant or some other sort of agreement. One other concept to keep in mind that Jim will cover in more detail, and that is the consistent enforcement of these types of agreements. Even though as a strategy, as a matter of strategy, as a strategic matter, in a particular situation, an employer may decide not to enforce an agreement with regard to a particular employee, it is important to remember that that may affect the ability to enforce the agreement in other contexts, in other situations in the future. It doesn't always mean that you wouldn't choose to adopt that strategy, but it's something to keep in mind that other cases may be affected by the strategy used in the current situation. With that, I'll turn it over to Jim McCluskey to cover the litigation implications of these kinds of scenarios.
I'd like to start off briefly by discussing the cost of litigation. That's a factor that every business owner should consider prior to jumping into litigation. As the two previous speakers, Ed and Bob, have mentioned, the proper drafting of a restrictive covenant agreement and a well-crafted restrictive covenant agreement will avoid litigation. Because when an employee leaves and it's clearly stated to the employee exactly what the terms of the restrictive covenant agreement are, they will know how to follow those, and it may actually follow those and avoid litigation. However, there will be times when you have to see a lawyer with respect to litigation. So the cost of litigation has to be weighed. You have to weigh that from a business factor versus the cost versus what you're trying to accomplish. Now, the court that you will probably end up in every jurisdiction, certainly in Illinois and in the United States, is a court of chancery, because you're trying to enforce an agreement that has equitable principles. The equitable principles are an employer's right to enforce an agreement versus an employee's right to earn a living. The restrictive covenant agreements usually come with a cause of action, and I will speak to that later on, known as injunctive relief. So when we weigh the cost of litigation versus the benefit received, that's the very first thing I discuss with a client who wants to seek litigation. Enforcement of written restrictive covenant agreements. Usually, it must be remembered that we're not only dealing with the employer and the employee, but we're also dealing with the prospective employer or the new employer, because the new employer will then get involved with respect to the enforcement of the agreement. Also, another point which I think is particularly important and crucial is that you're not only dealing with your employee, but a third-party employer, depending on the size of the company. You're going to be involved in some expensive litigation and detailed litigation. But you also might be involved with the customers, because you're going to enforce a restrictive covenant agreement. You will need evidence to show that the restrictive covenant agreement has been breached. And that is a business decision that has to be made before going ahead with litigation. First step in the initiate a litigation is to write a demand letter requesting that the employee adhere to the terms of the agreement. Not only the employee, but usually the new employer that would you would demand not to interfere with the restrictive covenant agreement. Those are the first steps. And at the same time, a detailed complaint at law, basically allegations saying that the employee breached the agreement, have to be drafted. And it should be sworn by the employer, a sworn statement that is provable in court. Very first allegation or count, as they call in a complaint, would be the breach of contract. The breach of contract is based upon the restrictive covenant agreement or the covenant not to compete. One basic duty every employee has to an employer is a duty of loyalty. And if it is breached, there will be a count for breach of duty of loyalty. Depending on the status of the employee, those duties rise to certain levels. If it's an officer or director that left the company without notice and then absconded with some of the business, it's a higher standard for the breach of loyalty that an officer, director, and a shareholder may have. Then you have to look at the status if it's a majority shareholder or a minority shareholder as to the levels of duties in the different jurisdictions. Now, the complaint usually consists of various counts. One of the important counts is a misappropriation of trade secrets. You heard Ed Mumpkus speak to that. And what I mean by that is an item that is unique, or a piece of material, or a computer code that is unique to the particular client, and that the client, your employer, keeps in a secret place. In other words, has it computer protected and does not allow the public to have access to it. A perfect example of a trade secret is the Coca-Cola formula. And if that's taken, there would be severe damage to the Coca-Cola company if that had been released without their permission. Some of the other items that you'd look at is the status of the employee. If you're talking about the director of sales, and a director of sales works for PepsiCo and moves over to another company that is in a very similar status, and does not walk away with any of the pricing formulas or any of the pricing strategies or marketing formulas, but is available inside their head, and you have a restrictive covenant agreement not to work at a competitor, it is inevitable if they go over to the same position to a major competitor, and they would then inevitably use that material that they've obtained from the employer to disclose it. So that's another cause of action under a misappropriation of trade secret doctrine. Typically in litigation, there is a claim for items that is taken from the employer. That is known as conversion. It's an unlawful removal of personal property or property of the employer without the permission of the employer, and taken by the employee to the detriment of the employer and to the benefit of the new employer. The other item I want to speak on is a tortious interference with contract. Although it's based upon a lack of contractual relationship, it has to do with a relationship between the employer-employee and the interfering party, usually the subsequent employer. And when the employer has been made aware of in the demand letter, the new employer, that there's a restrictive covenant agreement and that the employee is to be bound by that restrictive covenant agreement, the new employer would then, if they were guilty of interfering, would be tortiously interfering with the employer-employee relationship, the former employer. Also, if the employee went off to work for the new employer on a new business venture in which the previous employer had a stake in, that's called tortious interference with a business expectancy. And that is another cause of action that usually you see in complaints involving restrictive covenant agreements. Now, injunctions, as I spoke to those earlier, there's a three-step process in litigation. The first is what's called a temporary restraining order. That is usually at the start of the litigation, when a complaint is filed and you want to stop a process because there's damages being done to the employer. And you want to stop the bleeding as a litigator. You have to rush into court, and it is fast and furious. Not only do you draft a very detailed complaint, but you also draft a petition for a temporary restraining order. You want to maintain the status quo before there's any further damage done. And what you're trying to do on behalf of your client, the employer, is to stop the bleeding and allow the courts, the judicial process, to move forward, but to lessen the damage that was done by the breach of the restrictive covenant agreement. Temporary restraining orders are exactly what they're called. They're temporary. You have to then move on to what's called a preliminary injunction. That's in the middle of the litigation. That's usually within 3-4 months after filing the complaint. Now, the temporary restraining order is based on a motion or a petition and an affidavit and an argument by your counsel. There is no evidence heard, and the judge will make the decision on the spot in order to protect the interests of the employer from being further damaged as a result of the breach of the employee of the restrictive covenant agreement. The final injunction in a litigation is called a permanent injunction. That's after a trial is had on all the merits and all evidence is heard, and the court decides that the restrictive covenant has been breached and enters an injunction for the term of the restrictive covenant agreement. Now, one last thing on preliminary injunctions, I just want to back up a little bit. Also, that's evidence. The court cannot make a decision as to enter an injunction because what you're doing is you're restricting somebody's ability to move forward and make a living. And if you're doing that, the court will require evidence that there is a definite breach of the restrictive covenant agreement and make the employee adhere to the terms of the agreement that they signed and they received valid consideration for. One important note about injunctions. Injunctions are an extraordinary remedy. They're not easily granted. And in fact, they're a method to use probably at the last resort of any litigation. But they're a necessary thing in order to stop further damage to the company. What you have to show is a clear ascertainable right. That's shown by that you have a restrictive covenant agreement, and that's a right to move forward. The second thing is you have to show that there is irreparable injury to the company because of the conduct of the employee. And you have to show there's no adequate remedy of law, meaning you cannot calculate the damages that have been done in money terms by the employee to the employer. It's ongoing and it can continue unless a court intervenes and enters an order and enjoins the party from moving forward, enjoins the employee from competing. And at the time, even during the temporary restraining order, the judge has to be convinced that you have a likelihood that you're going to succeed on the merits of the case through trial. So it's a standard that has to be overcome. You have to have an experienced lawyer, and you have to put all your ducks in order with respect to an affidavit and evidentiary hearing, and you have to have the drafting of that restrictive covenant agreement is the guidepost for the litigator to proceed forward and to be successful. Finally, I'd like to talk about settlement. Settlement is always an option from the start of the litigation through the end of the litigation. It's always important to reassess through in all phases of litigation. Why is that? Because the employee will hire an attorney, the attorney will draft up, presumably on many occasions, a counterclaim or prepare a defense. And therefore, the facts or the circumstances may change, and you should always look toward settlement. 95% of the cases that are filed usually settle. You have to look at factors such as the cost of litigation, the business decisions sometimes. Some things happen during litigation or some things happen with your businesses that you will go in a different direction. Though a business decision will override the litigation. And always, when you're dealing with a court system and you're dealing with different judges, the outcome of the litigation is always questionable. Thank you.